of German medical personnel enthusiastically participated in the sterilization of 400,000 German citizens, the euthanasia of 5,000 young and 200,000 adult useless eaters, and the murder of 6 million Jews in concentration camps, only 23 of them were put on trial in Nuremberg in October of 1946. The indictments against the 20 physicians and 3 non-physician personnel does not focus on this staggering number of deaths, but rather on medical experiments that caused the deaths of less than 10,000 people. The judgments against the 23 defendants included a 10-point code of human experimentation ethics, known as the Nuremberg Code, propagated to protect patients who choose to participate in medical research. Prior to the 20th century, patients did not need protection in medical research because there was so little of it. The Hippocratic Oath, which does not even mention human experimentation, had protected patients for more than 2,000 years with such prescriptions as, quote, "I will neither give a deadly drug to anybody who asks for it, nor will I make a suggestion to that effect." Or similarly, "I will not give to a woman an abortive remedy." Or more inclusively, "I will abstain from whatever is deleterious and mischievous." But the physician's obligations and ability to protect the human body were overwhelmed by events of the 20th century. Jordan Goodman, Anthony McElligott, and Lars Marx, editors of Useful Bodies, Humans in the Service of Medical Science in the 20th Century, wrote, quote, in his 1924 novel, Magic Mountain, Nobel laureate Thomas Mann was sharply critical of the notion of the pre-Hippocratic body, the body that was defined simply in terms of its usability or non-usability. Yet, what he saw as anti-human was in tune with eugenic thought at the time and has been broadly accepted by the medical and scientific community since then, end quote. The human body was once again a useful commodity, and as such, it was subject to manipulation and abuse by powerful forces. The physician's obligations enumerated in the Hippocratic Oath failed to protect individual patients from the lethal interaction of the state and biomedical science as so graphically exemplified by the horrific Nazi medical experiments. Tonight, we will discuss the response of the judges in the doctor's trial to that failure with Professor George Annis, who will speak about the legacy of the Nuremberg doctor's trial to American bioethics and human rights. George Annis is the Edward R. Utley Professor and Chair of the Department of Health, Law, Bioethics, and Human Rights of Boston University School of Public Health and Professor in the Boston University School of Medicine and School of Law. He is the co-founder of Global Lawyers and Physicians, a transnational professional association of lawyers and physicians working together to promote human rights and health. He has degrees from Harvard College, Harvard Law School, and Harvard School of Public Health. How did you wind up at Boston University? Professor Annis is the author or editor of 17 books on health law and bioethics, including Public Health Law, American Bioethics, Crossing Human Rights and Health Law Boundaries, The Rights of Patients, one of my favorites, Some Choice, Law, Medicine, and the Market, Standard of Care, The Law of American Bioethics, and Judging Medicine, and a play entitled Shelley's Brain that has been presented to bioethics audiences across the U.S. and Australia. He has been ranked as the nation's most cited law professor in the field of health law. Professor Annis wrote a regular feature on law and bioethics for the Hastings Center Report from 1976 to 1991, and a regular feature on public health and the law in the American Journal of Public Health from 1982 to 1992, and since 1991 has written a regular feature for the New England Journal of Medicine entitled Health Law, Ethics, and Human Rights. He is a fellow of the American Association for the Advancement of Science, a member of the Institute of Medicine, and co-chair of the American Bar Association Committee on Health Rights and Bioethics. He has also held a variety of governmental, regulatory posts, including Vice Chair of the Massachusetts Board of Registration in Medicine, Chair of the Massachusetts Health Facilities Appeals Board, and Chair of the Massachusetts Organ Transplant Task Force. Please join me in welcoming Professor Annis, Holocaust Museum, Houston.
Thank you, Sheldon. It's a pleasure and privilege to be here to join this august group that you have in your lecture series. I will refer to some of the speakers you had before and at least one of the speakers you're going to have in the future during my talk. And I also want to leave significant time that we can have a dialogue about these issues as well. I mean, Sheldon is right. I'm going to talk about the trial, the doctor's trials. And I will talk about that, but mostly I want to talk about what it means to us, both to American bioethics, that's fine, what it means to doctors, but what it also means to Americans, and what it can teach us today in today's discussions on very closely related topics. We'll begin with Hippocrates and the debate that I've been having with both Sheldon just a little while ago with Art Kaplan about whether or not it is correct to think that American bioethics began at the doctor's trial, or whether we should date it from Hippocrates or from some other time in the future. And the truth of the matter is it can be quite artificial to say that American bioethics began at X date. You can pick all kinds of dates. But I'm going to make an argument tonight that American bioethics as we know it today really did begin at the doctor's trial, where American doctors, American judges, and American lawyers worked together to prosecute and ultimately convict the Nazi doctors for violations of human rights law, for sure, criminal law, for sure, but also of what we know now, and probably should have known then, as violations of medical ethics. This is the Palace of Justice at Nuremberg, and as many of you probably all know, it was one of the few buildings left standing at Nuremberg because of the Allied bombing. 95% destroyed. But the Americans wanted to have a trial at Nuremberg for all kinds of reasons, not just because of the symbolic value of Nuremberg, where some of Hitler's first decrees were enunciated from, where the annual rallies were held, but as important, I think it was in the American sector. And so any trial there would be dominated by the Americans, and that was an important consideration as well. Nonetheless, it is really important to understand that the first trial at Nuremberg, so-called big trial, the International Military Tribunal, consisted not just of the United States, but of the United States, Great Britain, the former Soviet Union, and France. It was a multinational tribunal, the first multinational tribunal in the history of the world. Never been tried before. So very interesting. And also, this multinational tribunal was making international law. Another new concept. There had been international wartime law, but there really wasn't the concept of international peacetime law before this tribunal. So, this is again not the doctor's trial that comes next, but you can't understand the doctor's trial without knowing a little bit about this International Military Tribunal, which was set up to try the so-called major surviving Nazi war criminals. Goering being the hit survivor. The Nuremberg, the IMT, or the International Military Tribunal, enunciated three basic principles, which we now know as the Nuremberg Principles. We'll talk about the code in a second. And you all know these, whether you know where they came from or not, right? That there are such things as war crimes and crimes against humanity, and murder, torture, slavery, genocide. It was called extermination at the time, but genocide came into vogue a couple years later. That individuals can be held accountable for committing war crimes and crimes against humanity, and that the defense of, which all the Nazi doctors defended themselves like this, and most of the original Nazi defendants in the big trial did too, the defense that I was just obeying orders, even more technical, that I was following the law of my country at the time. What I did was legal in my country. There's no defense at all to a charge of committing a war crime or a crime against humanity. Again, those are Nuremberg principles. They bind everybody in the world. That was a point of this trial. That was a multinational trial. The next set of trials are so-called subsequent trials, and there's a very nice exhibit of these 12 subsequent trials here in the museum, in the permanent collection that you should look at. Were all run by Americans. There were American trials. The other allies had their own trials in their own sectors in Germany and in their own countries, in France and England as well. But we held our trials all in the American sector and all there. And although they were military trials, we used civilian judges. We recruited civilian judges from the United States, from state and Supreme Courts primarily, and used mostly American rules in the trial to try Nazi defendants from 12 different sectors of the society. The first trial was the doctors' trial. We can argue a lot about why that was, but obviously the prosecutors felt that there was something especially evil, especially wrong, especially something that just didn't fit. To have physicians trained to heal, involved in killing, mass exterminations, experimentations, death, the euthanasia programs, and the sterilization program. And these are the 4 American judges, 3 judges and an alternate, who sat at the doctor's trial. And again, on the military, it's a military tribunal, even though it was done with civilian judges. The named defendant was Dr. Karl Brandt. No, he was Hitler's personal physician, but he was much more than that. He was also the channel through which Hitler communicated a lot of his private rulings, which became law. He got to make law all by himself, according to himself. And the euthanasia orders went through Karl Brandt, and that's the only thing Karl Brandt would accept any responsibility for at all, accepted no responsibility for anything that happened in the concentration camps. A number of people today, when I was wrong, but a lot of people always bring up the question, well, why 23? Why were there 23 defendants at the big trial? Why were there 23 defendants at the doctor's trial? Why did every one of the 12 subsequent trials have 23 defendants? And I used to ask that question too until I met one of the prosecutors at Nuremberg and asked him. And the answer is as prosaic as you could imagine. That's how many chairs there were in the dock. That's it. That's it. One of the prosecutors brought 400 cases, and he was told, pick 23. Pick 23. It's all we have room for. But it wasn't that there were only 23 doctors or 23 husbands or 23 bankers or 23 judges. That was the size of the court. Literally true. This is the prosecution table. General Taylor. General Taylor was one of the assistant prosecutors at the big trial. He was Colonel Taylor at the time, and he agreed to stay on and prosecute the other 12 as long as they made him General Taylor. And that wasn't just for vanity's sake. But we were in the American military sector. The sector was under military law, and everybody there agreed. You couldn't get anything done. You couldn't get meals, you couldn't get a secretary, you couldn't get any help unless you were at least a general. It just didn't happen. So that's why he wanted to be general, because he needed authority to run this. But all his assistants, as you can see, are all civilian lawyers, and they came over from the United States after the war to take part in prosecution on 12 trials. And General Taylor, when he opened the trial, very eloquent opening, said a number of things. I'm going to quote a couple of paragraphs from his opening remarks because they're very powerful. He said, "The defendants in this case are charged with murders, tortures, and other atrocities committed in the name of medical science. The charges against these defendants are brought in the name of the United States of America. They're being tried by a court of American judges." We should never forget that. "To kill, to maim, to torture," and this is Taylor, "is criminal under all modern systems of law. But these defendants did not kill in hot blood and are not ignorant men. Most of them are trained physicians. Yet they are responsible for wholesale murder and unspeakably cruel tortures. The perverse thoughts and distorted concepts which brought about these savageries are not dead. They cannot be killed by force of arms. They must not become a spreading cancer in the breast of humanity. They must be cut out and exposed for the reasons so well stated by Mr. Justice Jackson in this courtroom a year ago at the big trial, right? Jackson said, "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated." So Taylor is making lots of points there. Point it's an American judges, American trial, whatever law they make, they believe is international law, but for sure it applies to America. We're going to take this here. Secondly, yeah, they're going to concentrate on the human experimentation, but let's say it up front. This is murder and torture. This is not a hard case. The Nazis are using the excuse that they're involved in legitimate scientific practice, but nobody's buying that, and Taylor's telling the judges initially, just look at this as a garden variety murder-torture case. What's interesting, sick but interesting, is that there are physicians involved in this. That's why we want to document this and try to figure out how it happened and hopefully how to prevent it again. As I said, there are American physicians involved too. It's not a flattering portrait of Leo Alexander bending over there, showing one of the victims of the experiments. But Leo Alexander was a big-time military physician who became a civilian and then came back to Nuremberg to help in the prosecutions. He was Taylor's basically personal assistant physician in this case. And the other physician involved was Andrew Ivy from the American Medical Association, tasked to come over and testify as well at the trial. The experiments, and there were a whole list of experiments, but the most famous or infamous experiments at the trial were the so-called freezing experiments and cold water experiments. And it's a picture of the Nazis, whatever else you say about them, did document their experiments. Well, took their own pictures doing the experiments of themselves. Apparently they're proud of these experiments. As Roscher and his assistant doing cold water experiments, seeing how long it took someone to freeze to death and whether it was possible to rewarm them or not. And the so-called high altitude experiments, where you put in a chamber raised to a altitude at which Nazi flyers might have to bail out, and then a simulated drop is done in the chamber to see when you would die, and what the cause of your death would be. So these experiments and many others like them were done, again, according to the physicians that did them, because of military necessity. Right? Not that they wanted to do these experiments, although that evidence showed that's not true. A lot of them didn't want to do these experiments. But they were done under wartime emergency conditions and were necessary in order to save the lives of the armed forces of the German Army, Air Force, and Navy. That was the excuse. The judges not only had very little trouble finding most of the defendants guilty of murder and torture, but also decided that it was important to look forward, not just backwards. Because again, even the excuse was human experimentation. So the judges decided that they would develop, based on the evidence, what has become known as a Nuremberg Code of human experimentation to guide future experimenters. Obviously, the Nazis were not interested in consent and in any of these other finer points of medical ethics. This was for the future. And the Nuremberg Code, and I'm sure most are familiar with the Nuremberg Code, the first principle of the Nuremberg Code is that the informed, voluntary, competent, and understanding, all four of those things, informed, voluntary, competent, and understanding consent of the research subject, is absolutely essential. Period. It's also the most controversial part of the Nuremberg Code. Article 9 gives the other side to that the research subject has the right to withdraw from the experiment at any time. And then the other 8 provisions of the Nuremberg Code have to do with the obligations of researchers to protect the welfare of their research subjects by minimizing any possible risk, by using only scientifically valid measures, by taking steps to ensure the health and well-being of the individual subjects, etc. Okay. Very famous code, but as we're going to see soon, it has a very, to this day, an ambiguous legacy. I think, so I want to make sure I don't forget to make this point, I think the most important part of the Nuremberg doctor's trial is the trial itself. The fact that the physicians involved in these experiments, these murders and tortures, were held accountable for what they did. Were held accountable by judges, lawyers, and their fellow physicians from other countries. That's the most important thing. The code is important, but the code is more a historical document than a point of lasting and enduring legacy from the trial itself. This can be seen probably better by looking not at the war crimes trials in Germany, but at the war crimes trials in Tokyo. Most of you have never heard of. Hardly anybody's ever heard of these trials because they were done very poorly. Right? Instead of having 4 countries do these trials, there were 13 countries doing these trials. 13 judges, that's correct. And in the middle of the first trial, and then turned out to be the last trial, the Chief Justice from Australia decided to take a vacation and go home for 6 months and adjourn the whole proceeding. At the end of the first trial, General MacArthur decided he didn't want any more trials. He was the Supreme Commander and Governor of Japan at the time, and so his rule was law, and that was the end of it. More disturbingly, MacArthur, although he knew about the German trials, knew about the doctor's trial, followed the doctor's trial, decided with the Japanese doctors who were involved in atrocities in China, which Sheldon Harris documents in his book Factories of Death, that he would make a deal with the doctors. If the Japanese doctors told MacArthur what they learned from their biological experiments on the Chinese, he wouldn't prosecute them. And they didn't. Right? And that's how we got all the information that the Japanese learned from their experiments on Chinese and American prisoners of war as well. Not a very, not one of the finer moments in American justice. More disturbing, when we got back to the United States, we decided to do our own experiments. One of my good friends, the late Herman Wygotsky, who some of you may know, was in the Air Force at the time. He's from San Antonio. And he recounts that he was called by his superior officer and said, wait, he said, we're bringing 200 Nazis to Randolph Field and we want you to use them in your aviation experiments. Which Wig, to his lasting credit, said, I quit and left the military rather than get involved in that project. But we did bring lots of Nazis to the United States to use in our own research projects and not just in our rocket, Werner von Braun and his boys in our rocketry, We also did them used them in high altitude experiments here in Texas, and in the radiation experiments all around the United States. Radiation experiments came to light only during the Clinton administration and during the historical review of these experiments. And the justification for doing various high dosage radiation experiments on Americans was military necessity. Right? We gotta keep ahead of the Russians. The Soviet Union is a big threat to us, threatens our security. We have to find the answers to these questions. When General Eisenhower became President Eisenhower in 1953, he got a different kind of a legacy. One of the first things Eisenhower did, remember Eisenhower was a Supreme Allied Commander during the Nuremberg trials, and the governor in Germany as well. He instructed the Secretary of the Department of Defense to adopt the Nuremberg Code wholesale as department policy, and brought it in. And I would argue it's part of American law in any event. But Eisenhower made it official, certainly in the Department of Defense. It was a military code, and it had to apply there. But ever since Nuremberg, and maybe even before, American physicians have had a very difficult time distinguishing, and so have American patients, distinguishing research from treatment, distinguishing a scientist from a physician. Scientists test a hypothesis to find new knowledge. Physician should act in the best interest of his patient with the patient's consent. And distinguishing a subject from a patient. A subject, someone who you test your hypothesis on. A patient, someone who you try something. If it works, you keep doing it. If it doesn't work, you try something else. But you don't keep doing it just to test a hypothesis. Jay Katz, I think the world's leading expert on informed consent and on Nuremberg as well, has argued that these are almost intractable problems, at least with sick people. That sick people will always see themselves as patients and not as research subjects. The physicians will always see themselves as physicians and not as researchers, right? And that it is very, very difficult, therefore, for either doctors or patients, researchers and subjects, to see what they're doing as medical research rather than as treatment. And we just keep that in mind when we try to figure out how we can regulate research and why the Nuremberg Code has been so controversial, especially its requirement, absolute requirement for voluntary, competent, informed, and understanding consent. This is the most ambiguous legacy of Nuremberg, it seems to me, and disturbing, as I found it disturbing. The World Medical Association was founded during the war in London to give doctors from the European countries that were under occupation a place to meet. One of the things they did was come out with a giant statement against so-called socialized medicine right after the war. But the other thing they decided to do was to try to marginalize the Nuremberg Code. This is true, I would never have believed that. But they thought the Nuremberg Code was too legalistic. And it was a legal code, not a medical ethics code. And ultimately tried to displace it with the Declaration of Helsinki. So that's fine, they can do that. Although they can't displace a legal code, which is international human rights law, with an ethics code. But in 1992, the World Medical Association did something that even I wouldn't have thought that they were capable of doing. And I hope you didn't either. They elected a Nazi as their president. Not a neo-Nazi, a real live Nazi doctor, a member of the Nazi Party and the SS, who was implicated in killing, in the T4 killing program, euthanasia program. And he was elected as president. Now, I said at the time, I mean, I was a younger guy at the time, that should disqualify the World Medical Association from ever saying anything about medical ethics again. And the president of the AMA, Nancy Dickey, at the time, said, she thought that was a little harsh. That we should be able to forgive people. And what I said then, and I'll say it again tonight, is that if electing a Nazi doctor as your president doesn't disqualify you from making medical ethics pronunciations, what would? Is it possible to do something worse? I guess you could go out and kill patients again and relive the Nazi doctors. But to glorify one And it's not that they didn't know who this guy was. He was treasurer of the organization for 20 years. Perfectly well. In any event, it took a worldwide outcry, there was a worldwide outcry, for them to finally decide, well, maybe they shouldn't be president of the society, of the World Medical Association. So, we can talk. On the more positive side of the ledger, we have the whole development of the human rights movement after World War II. And whether or not you're going to buy the notion that American bioethics was born at Nuremberg, there's no question that international human rights was born at the Nuremberg Tribunal. It's not the Doctors' Tribunal, although we'll see it has a place in there, but the big tribunal. Eleanor Roosevelt was the chairman of the drafting committee of the Universal Declaration of Human Rights, which was promulgated in 1948. And Article 5, the one we'll look at the most tonight, read at that point that no one shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment. It may sound a little, unfortunately, familiar to Americans these days, as we discuss that ourselves. But that was not controversial after World War II. That was a declaration. In 1966, a treaty was promulgated, signed immediately by the United States, and we also sponsored this treaty all around the world, the International Covenant on Civil and Political Rights. And it has the identical section, now it's Article 7, no one shall be subjected to torture, to cruel, inhuman, or degrading treatment or punishment. But now it has a new sentence, taken directly from the Doctors' Trial. So if nothing else, the Doctors' Trial has a direct impact on international human rights law. In particular, no one shall be subjected without his free consent to medical or scientific experimentation. And there's lots of things to talk about on this, but let me just note to you, you can see it, that in terms of international human rights law, human experimentation without consent is torture. It's a type of torture. And it is, you can say not looking at medical records is one thing, but if you're subjecting the human body to pain and suffering to try to test the hypothesis, what else could it be? And that's certainly how the international community looks at it. The other thing that was going on in peacetime, and that's the only time you can do this, was to try to develop better rules for wartime. All right? To try to develop so-called humanitarian law, my favorite word. Humanitarian law is a fancy international word for the law of war. Trying to make war more civilized, if you will. Trying to care for civilians and prisoners of war, especially. So in that field, we got a whole new rewrite of the Geneva Conventions, the old Hague Conventions and the old Geneva Conventions, into new Geneva Conventions to try to protect prisoners of war and civilians better. And Common Article 3 that we've all heard so much about in the last couple of years, it's common article, it's common to all four of the Geneva Conventions, says this, that persons shall in all circumstances be prisoners, this is, shall be treated humanely, and the following acts are and shall remain prohibited at any time. Violence to life and person, in particular murder, mutilation, cruel treatment and torture, and outrageous upon personal dignity, in particular humiliating and degrading treatment. And we're going to see, just like the Universal Declaration of Human Rights, in later versions, human experimentation gets put in this as well. This brings us up to Abu Ghraib, something no one's proud of, obviously, especially in this country. But in a million years, we may have been able, like we could imagine Abu Ghraib, we could imagine lots of atrocities in Vietnam. But could we ever imagine Americans posing in the same kind of poses that the Nazis posed in, with freeze? This gentleman turned out to have been murdered, but they froze him there to try to cover that crime up. And then Grainer and Harmon have to pose with the guy to send their pictures home, or something that they apparently were proud of again. We're proud of doing. And we've seen all these photographs from Abu Ghraib. And my colleague, Dr. Michael Grodin, will be here next month, December 11th, to talk about, he's a psychiatrist, we're going to talk about whether, where does this come from? How do people learn how to do these things? And what does it tell us about humanity? But I mean, what does this tell us? Not just that we do these things, but we take pictures of them and are proud of it. Janis Karpinski, as many of you know, was the commander at Abu Ghraib when this was all going on. And General Karpinski, who was the only high-ranking officer to have any consequences in her career to the Abu Ghraib scandal, General Karpinski recounts in her book that when she was in charge here, that the military sent over General Miller from Guantanamo to, quote, gitmoize Abu Ghraib, to get some information from these guys, to soften them up. And she says in her book that Miller told her, I want you to treat those prisoners like dogs. I want them to believe they're dogs, and not human beings. And that makes perfect sense, right? Because if you're going to torture someone, humiliate them, treat them inhumanely, it's really a lot easier to do if you dehumanize them first. Right? I mean, the Nazis, I'm not saying these people are Nazis, but the Nazis certainly learned that. I mean, that's what you have to do is make someone a subhuman, then you can do what you want with them. And even though General Miller has denied it, just given what our troops did in Abu Ghraib after Miller came there, it's hard not to believe General Karpinski when she says that was exactly the order that went down, to treat these prisoners like dogs. Lindy England apparently took it literally with her leash. 2 years later, the U.S. Supreme Court, very famous Hamlin decision, ruled that Common Article 3, regardless of what the President says, and regardless of what Congress said, is binding international law, and binding on everybody, including the United States, and binding on all our prisoners, no matter where they're held, whether in Guantanamo or anywhere else. And we already saw that you have to treat all prisoners humanely and following that. The White House likes to talk about World War II a lot. Not a lot lately. It had been for years. And Churchill was always the person that they like to compare themselves, especially the president, to. He wasn't an appeaser, he was a tough guy. And that was the model that they should look at to World War II. And like most people, I'm an admirer of Churchill as well. But I usually find that people who think that they're following historical figures have no idea what the historical figures are following, have actually done. And when you read Churchill's memoirs, and he's the only big-time World War II guy who wrote memoirs in detail, so a lot of historians think that you can't believe everything he said, and then he gets way too much credit for writing the history of World War II. Leaving that aside, Churchill makes a big deal in his memoirs of the Nuremberg trials, big trials, and especially what he calls the most terrible decision that Hitler made on June 14th, 1941, when he was with two of his generals, General Keitel and General Halder, planning the invasion of the Soviet Union. And the decision was this. This is, again, according to General Halder's testimony at the Nuremberg trials, that he said Hitler told us, and this was all verbal, that we were in a new kind of war with Russia. This was a special Russian struggle, that the Russians were not signatories of the Hague Convention, and therefore they were not going to be prisoners of war, and we did not have to follow the articles of the Hague Convention and the Geneva Conventions in treating their prisoners of war. General Keitel, who was deposed but didn't testify at Nuremberg, said that Hitler's main theme that day was that this was a decisive battle between two ideologies, and that this fact made it impossible to use the conventional Geneva Convention's methods as we soldiers knew them, which were considered at that time the only correct ones under international law. Now, the argument is not, my argument is not that Bush was acting like Hitler when he said we could suspend the Geneva Conventions. They don't apply in Guantanamo because the Taliban hasn't signed the Geneva Conventions, and this is a new kind of war. No, I don't think that's for a second. What I do believe, though, is that the people in the White House knew absolutely no history at all. If they didn't know in this history, there's no way that they would have set the president up to use almost precisely the words and the logic and the language of Adolf Hitler. As the Alberto Mora, the General Counsel for the U.S. Navy, from 2001 to 2006, the 5 years of the War on Terror, said, quote, "I wondered if they, all the administration's civilian lawyers, were even familiar with the Nuremberg trials, or with the laws of war, or with the Geneva Conventions." The answer, you don't have to wonder. The answer is no, they're not. They have like no idea. And we've now seen enough memos from these guys to know they have no clue to international law. They just know they don't like it, they don't want it. And that was true from Gonzales all the way down, or all the way up, whichever way you want to go on that. As Barry McCaffrey pointed out, among other things, that this whole idea of enhanced interrogation was a Gestapo technique. Again, I don't think we adopted the word enhanced interrogations because that's what the Gestapo did. I think we didn't know what the Gestapo did. Don't know that history. Never would use the word enhanced interrogation if we didn't know what that did. You see, even the Gestapo, by the way, wanted a doctor present if you're going to strike more than 20 blows on a prisoner that you're doing the third degree to. Most disturbing, since I'm a lawyer, to me, is not what the doctors have been doing, but what the lawyers have been doing lately. And when our new Attorney General says he doesn't know whether waterboarding is torture, you just gotta wonder what the hell, what's the deal here? Who's he trying to protect? Well, he told us. He wrote a letter to the Senate committee and said, "I'm trying to protect our guys who've been waterboarding. I don't want them to think if they rely on the statement of the Attorney General, not him now, but his office, that what they're doing is legal, that they might be putting themselves in legal jeopardy." Well, why not? Again, I don't know this guy, our new guy, very well, but if you know anything, and really, if you know anything about international law and the Nuremberg principles, what do you know? You know, obeying the law of your country is no defense, right? International law is international law. No individual country can change it, no president, no Congress, no Attorney General, right? Torture is international war crime. End of story, right? Obeying orders is not an excuse. End of story. So this is bizarre stuff. This is how far we've fallen. Our bioethics people know better. At least they did before the War on Terror. Leon Cass, who was here before, his Bioethics Commission published a book of readings and literature. Very good book. And one of the readings was called A Case of Torture. And it was about a former Soviet dissident who wound up at Leon's University of Chicago, and describes how he was treated by the Soviets in the 1970s when he went on a hunger strike to protest the fact that one of his friends wasn't going to have a lawyer when he was tried. He says, "They put me in a straitjacket, they dragged me into the medical unit, they rammed a feeding tube up my nose, and it was very painful and horrible and awful, and they did that every day, twice a day, for 12 days. And again, the President's Bioethics Commission had no trouble saying, that's a case of torture. There's no excuse for doctors to do that. And nor did we, in the 1970s, have any trouble saying, when the Soviets do stuff like that, it's torture, it's inhumane, it's horrible and miserable, and there's no excuse for it. When we do it, it's okay. Right? We've been force-feeding people at Guantanamo almost since the day it opened, but viciously force-feeding people there for the last 2 years. Honor-bound to defend freedom. I mean, I do think most of the military people are honor-bound to defend freedom. I don't think the people at Guantanamo have anything to do with honor. And I think it's a disgrace that they have dragged in his chair. His chair was brought from the mainland a year ago, last January. The hunger strikers at Guantanamo were strapped into this chair, in 6-point restraints, including your head, stayed there in that chair for a period of 4 hours, and very much support the feeding tube is put down their nose, and they're told that they're going to keep doing this twice a day until you start eating, one way or the other. The chair, I believe, is a functional equivalent of the straitjacket, and the fact that we can't see this, or don't see this, as torture is inexplicable to me. On the other hand, if you wanted to say, well, it's not torture, it's just cruel and inhumane treatment, okay, we can make that argument. Doctors are doing this. That's the problem. Doctors are doing this. I've even suggested maybe you could see this if you don't want to see force feeding's okay. You can see this as a medical experiment done obviously without consent. Chairs like this have never ever been used in medicine. They're used for transporting prisoners from the prison to the hospital. But they're being used today, literally today, as we talk, to force feed prisoners at Guantanamo. Prisoners never convicted of anything. 90% of them never even charged with anything. In any event, not something that we've ever thought could be done in America. Protocols for the Geneva Conventions, I mentioned to you, a follow-on from the 1949 conventions, these in 1966. Protection of persons, it is now prohibited to subject persons to any medical procedure not indicated by the state of the health of the person concerned, which is not consistent with generally accepted medical standards. That is a merger of medical ethics and international human rights law, by the way. And number 2, it is in particular prohibited to carry out on such persons, even with their consent, physical mutilations and medical or scientific experiments. So that's international human rights law today. The state of prisoners is so precarious that no one really believes they can give consent. People said, obviously Nuremberg wasn't about consent. And so it's prohibited to doing experiments on prisoners. Customary international law is the same. Torture prohibited, medical and scientific experiments prohibited. Justice Jackson, who I mentioned before, Telford Taylor quotes in his opening statement, Justice Jackson was the prosecutor at the big trial. Justice Jackson made lots of important points, but for us I think there's 2 important ones. One, was Nuremberg really a victor's justice? That was what the Germans always said. It was kind of a sham trial, show trial. We always accuse the Russians of that. And it wasn't real. And what Jackson said is, there aren't any other places we can do this for them. Either we try you or we let you go, basically, or do something else. So we want to make international law. So if we're going to try you, we know we've got a heavy burden. We've got to bend over backwards to be fair, just, give you rights of cross-examination you wouldn't really usually have, rights of legal counsel, of course, guilt beyond a reasonable doubt, they did all those things. So Jackson understood that was a problem. But what he said at the end, he said the most important part of Nuremberg was that we had to accept the rules that we were trying the Nazis by ourselves. Right? That we had to be bound by whatever rules we came up with. And he put it this way, almost poetically. He said, if we pass these defendants a poisoned chalice, we put it to our lips as well. We can't live by these rules. We're no better than that, essentially. All right. So where are we today? That's a good question. We've seen during this whole lecture series how a beginning of racial hygiene and eugenics led all the way down to mass killing and extermination. Today we're trying to, I think, reinvent eugenics and try to make something good out of it. At least use genetics for a good cause. It can be usable for a very good cause, right? When the human genome was decoded, was first mapped and sequenced, it was published simultaneously in Science and Nature. Both Venter's private, one and Francis Collins will be here later, public project one. And the artists who did both covers both went out of their way to try to show that we're all members of the human community. You can't really see it on the Nature slide, but those are all little faces. Lots of tiny little faces making a mosaic of the human being. And in the science one, you can see that it's the human tree, that we're all related to one another. As the head of the Science Museum in London put it, what this project shows is that we're all Africans under the skin. As Craig Venter said, it shows that we're all intimately related. We're all 99.9% identical. And so that code, the genomic code, at best, should, I think, match perfectly with the Human Rights Code, the Universal Declaration of Human Rights, which is based on the same notion that we're all the same. Non-discrimination is absolutely required. All human beings, no matter where they're from, what their race is, what their ethnicity is, what their religion is, all must be treated the same under international human rights law. And you can see science and medicine working together with human rights. In that, we're all familiar, I'm going to find your opening speakers here said a couple weeks ago, to his everlasting shame, James Watson said in London, quote, you have to quote him, "I'm inherently gloomy about the prospect of Africa because all our social policies are based on the fact that their intelligence is the same as ours, whereas all the testing says, not really. And while I would like to hope that everyone is equal, quote, people who have to deal with black employees find this is not true." So, a lot of people argue that Watson was drunk or crazy and he says stupid things like this all the time, which is true, but not quite so racist. Now, is Watson racist? No, I don't think so. But we're not going to say that. What we're going to say is it is not, racism is not the problem. Racism is a big problem. It was obviously a big problem in World War II and in Nazi Germany, especially with the Jews, but not just the Jews, but the Slavs, the Gypsies, lots of hate groups based on race. But the real problem for us, I mean, racism again, we're not done with racism, unfortunately, is what I call genism. Racism is the belief that human characteristics and abilities are determined by race, which seems to be what Watson is saying. But what Watson is really saying is this, is genism. Is the belief that human characteristics and abilities are determined by genes. That's where we came in, with eugenics, racial hygiene, the notion that you had to sterilize people, control breeding, had to watch out for genetic intermixtures, because basic human characteristics are determined by genes. This is the ultimate in reductionism and determinism, widely discredited views, but which take human beings and don't look at them as human. Don't even look at them as dogs, right? Look at them as a group of molecules. And Watson is very fond of saying, he does say over and over again, that once we understand the human genome, we will understand humans at the molecular level. Francis Collins said that too, but I don't think he means it. He did. The problem with that, of course, I think is quite obvious. Humans don't live at the molecular level. What goes on at the molecular level may or may not be all that important, but whatever it is, it's part of the human body. But it ain't human. It ain't human behavior. It ain't human action that we have responsibility for. And we shouldn't act like we're just a collection of genes, and that we can actually go back and look the way the Nazis did under the microscope and find out what's going on. There's a famous Nazi propaganda poster where they see not just the Jews in the microscope, but the communists as well, and even some capitalists who are infecting the German blood. The caption reads, "With his poison, the Jew destroys the sluggish blood of weaker peoples, so that a diagnosis arises of swift degeneration. With us, however, the case is different. The blood is pure, and we are healthy. The genes are pure, and we are healthy." Genism really is a threat that we have to deal with today. And the way we deal with it is by the lesson of Nuremberg, the lesson that we really are all the same, that it is insane to try to concentrate on our differences. That we'll find them, we're going to find differences and use them to viciously discriminate against people. We don't have to be encouraged to do that by science, unfortunately. And I want to end with a couple of my favorite statements. One is from John Kennedy, very famous statement, but it's worth repeating for all kinds of reasons, not the least of which, it's hard to remember. Well, I lived through it, many of you did too. The Cuban Missile Crisis, when the world came as close as ever come to annihilation, to an all-out nuclear exchange with the Soviet Union that could have destroyed both countries, and all of us sitting here today. Yet within 6 months of that standoff, Kennedy had no doubt the Russians were not our friends, they were our enemies, and they could have destroyed us. He was ready to say, look, we've got to live here together. In his American University speech, the famous words he said, let us not be blind to our differences, but let us also direct our attention to our common interests. For in the final analysis, our most common link is that we all share this small planet. We all breathe the same air. We all cherish our children's future. And we are all mortal. Saying it in better words than most of us could say, that we're all the same. And if we don't work on our differences, we're going to wind up killing each other. Last time I was in Houston, not long ago on May 1st, I heard the Dalai Lama speak, not far from here. Some of you, I'm sure, had that privilege as well. And the Dalai Lama puts it even more precisely. He ended his speech that day saying, 600 billion people, one planet. That's it. Get a lot. So, I think that's right. Dr. Grote and I are working with Nuremberg as our inspiration, having doctors and lawyers work together. Normally they don't work together very well, but they can. In human rights, they work together at Nuremberg, and I think they work together well here. Lots of other groups are working on human rights as well, and especially, I think, important to note that many of them are physician groups. That physicians are really, I mean, lawyers are working here, but physicians have been out front of this. Physicians really understand, I think, what's at stake in human rights, probably more than probably any other profession. But groups like Physicians for Human Rights are outstanding. Physicians that work around the world, and it's just it's sad that I think it's sad. It's tragic that in the last couple of years, Physicians for Human Rights, Global Lawyers of Physicians, other groups have had to spend most of their time working in the United States, trying to convince our government and others that to convince someone that torture is wrong, that at least physicians shouldn't be involved in torture and inhumane treatment of prisoners, shouldn't be involved in human experimentation of prisoners. The answer is yes. The answer is yes. We don't have to call our guys Nazis. We don't have to call ourselves Nazis. But we have to learn something from the Nazis, and not from the Nazis, but from the American prosecutors, the American judges, the American doctors at Nuremberg. All of them said, with a single voice, all right, there are such things as war crimes and crimes against humanity. Individuals have to be done. It's simply not.